in Newark, the Wolf Musling undergarment factory, and in November of 2010, a fire broke out that killed 26 workers. On March 25th, 2011, a day after the liability law of New York was ruled unconstitutional, there was a massive fire at the Triangle Shirtwaist Company that left 146 workers dead. There's a rumor that the stairways were in part blocked so to block union organizers from entering the workplace. People jumped out of the windows. There are terrible pictures on the internet. There's actually a picture of the fire engine rushing to the site. That brought the unions closer to the Tammany Hall, and then later in 2011 in New York, as well as in New Jersey, we had no-fault workers' compensation issues. Let's talk about causation. The New Jersey statute says that accidents arising out of the course of employment, of which the actual or lawful imputed negligence of the employer is the natural and proximate cause, is compensable, provided that there was no willful accident, willful negligence on part of the employees, such as in horseplay, when people were rushing aloud, slashing fluids at each other, and this kind of thing. Occupational disease is defined as a disease, quote, due to a material degree to causes and conditions which are a work characteristic of and peculiar to a particular trade, occupation, process, or place of employment. For example, lead paint used to bridges. Sandblasters come and blast off the old paint. They inhale the lead paste and become ill. The Hunter's Book of Occupational Illnesses, the British book, describes occupational illness from arc eye in the welder to weaver's bottom in the weaver. However, the statute says that a deterioration of a tissue, organ, or part of the body in which the function of such tissue, organ, or part of the body is diminished due to the natural aging process is therefore not compensable. And then your job will be to sort out what is what. My friend, Ms. Cohen, told me to add something on exacerbations, because if old knee arthritis flares or lasts for a short while, then that flare becomes compensable, and so does acceleration and aggravation of the underlying condition. We'll discuss these definitions below. As it relates to cardiovascular disease, stroke, the statute says that there has to be credible evidence that the injury or death was produced by the work effort or strain, and here it comes, involving a substantial condition, event, or happening in excess of the wear and tear of the claimant's daily living, and in reasonable medical probability caused in a material degree the cardiovascular or cerebrovascular injury. And then it says that material degree means an appreciable degree, or a degree greater than de minimis. That term de minimis is nowhere defined. Perhaps it could be translated as negligible. The role of the doctor then is, for the subject of cardiovascular, cerebrovascular accident claims, the statute provides a criterion of a substantial condition, event, or happening in excess of the wear and tear of the claimant's daily living. Therefore, the expert must state whether or not the medical event occurred during or after a substantial condition, event, or happening in excess of wear and tear of the claimant's daily living. And the first rule of the doctor in this matter is to be a witness as to what really happened. Okay? So, there's statutory presumptions, namely cardiovascular and cerebrovascular injuries in police, firefighters, and emergency personnel while responding to emergencies, and those are presumed work-related on the way to, on the side at, and the way back from the event. There is a rule regarding cancers and firefighters, who we discussed below. And the year before the onset of COVID, there was an extension to the statute passed that severe communicable diseases are presumed work-related. As to the presumption of work-relatedness of cancer and firefighters, the statute says that the firefighter has to complete 7 or more years. It is unimportant whether the firefighter is actually working or not when the cancer is diagnosed. And the rule goes for both active firefighters and volunteer firefighters. However, these people should not be more than 75 years old in order to qualify under the statutory presumption. So 7 years of service, professional or volunteer firefighters, diagnosed at age 75 or before, having worked for 7 years or more. Okay, now, when it comes to pre-existing and underlying problems, pre-existing means that I've had this before. Predisposition is I might get it. I have Celtic skin, I get sunburn. If you say sun to me, I start burning. It runs in my family. Precipitation or elevation is the unmasking of a previously asymptomatic disease process by an event of exposure. Somebody bumps the knee, you take an X-ray, the joint space of the knee is gone due to degenerative osteoarthritis, although the patient never felt it before. Recurrence is symptoms or signs of a resolved prior injury or illness that reappear without a provocative event. Now, here's something important. Obviously, approximate cause means it happened now and for the first time. The ultimate cause means that it happened before, and this will have to be considered. In the treatment phase, the proximate cause triggers the treatment, even for a flare of an underlying condition, as long as that flare lasts. However, the ultimate cause then governs the speed of recovery. In the settlement phase, the ultimate cause triggered an apportionment of the disability recommendation by the examining physician. So let's take an example, talk about carpal tunnel syndrome. There are certain conditions such as obesity, diabetes, hypothyroidism, rheumatoid arthritis, and biopsychosocial circumstances, namely misery, that are in and by themselves strongly linked to the creation of carpal tunnel syndrome. However, if there's a work exposure, then these factors also enhance the likelihood of developing carpal tunnel syndrome. So there you have a complex issue of pre-existing factors that are in and by themselves competent causes and aggravating injury. There are two references that I recommend to you. Melhorn's book is the Bible. There is a NIOSH report that also contains reference regarding causation. Here is the Melhorn book. Let's talk about recovery, maximum medical improvement and what that means, and disability. So here's your person that has cerebrovascular disease, and unfortunately is going downhill. And you see this person here, and you have to make a decision. Can I treat, for example, do an iliofemoral bypass or do a coronary artery bypass? Is there only palliative treatment, or are we so late that treatment is only expectant? And all this is things that we consider in our bioethics considerations. Fortunately, however, normally what we see is we have a patient that starts without any impairment, then falls, breaks the hip, has surgery, recovers, and ultimately reaches a plateau where that person is about as good as he or she is going to get. It is my rule of thumb that if that plateau lasts about 3 months, then you have a right to declare maximum medical improvement. Other people are not so happy. They have, like, for example, a retroverted acetabulum of the hip, or prior hip arthrosis. Now they fall, they break the hip, they recover, but not as well. And in fact, the recovery may take slower, but they do reach a plateau. And all this then describes maximum medical improvement, as good as he or she is going to get. What tells you that there's maximum medical improvement? I tell you, this is a judgment call. There is nothing in the statute. You would perhaps like to have the patient febrile, control pain, no residual inflammation, no residual tenderness. That's hardly the case. Full range of motion hardly ever happens. No restrictions, scars, or hernias. Neurological impingement of root plexus or peripheral nerve. This is very important. You want to have restored confidence. Nothing works unless you do, is what Maya Angelou said. You want to see normal gait and posture, matching strength, right and left, minimal impact on activities of daily living. You want that person back at work, fully or partially. But realistically, sometimes MMI is declared because the patient is tired of going to the doctor and doesn't feel that he or she is being helped, or the doctor is tired of the patient. Now, excuse me, this is a cynical view, but it does happen. Disability is defined by the statute. Disability permanent in quality and partial in character means a permanent impairment caused by a compensable action or compensable occupational disease based upon demonstrable objective medical evidence. That's the most important thing here, which restrict the function of the body or its members and organs. So there are two things. There has to be demonstrable objective evidence, but it also has to lead to a restriction. Included in the criteria which shall be considered shall be whether there has been a lessening to a material degree of an employee's working ability, or for that matter, it doesn't say in the statute clearly, material impact on activities of daily living. And your job is then to define that. Injuries such as minor scratches, scrapes, sprains that heal, or mild bronchitis do not count in the determination of disability. There may be temporal impairment, but no permanent disability. Now, you may be surprised that doctors have three totally different roles. And I'm telling you that from experience. I've been in court numerous times. I've done 37,000 IMEs. My father used to say, braggarts get more out of life, so please forgive me for mentioning that, but that's what my talk is based upon. First, you're an observer. You observe what happened. This very experienced doctor once yelled at me, Dr. Blumenthal, you're part of the discovery. You describe the exit mechanism. You have to describe the exposure. You have to look at the exposure data. You have to find out whether, for example, in a car accident, it was a rear and a front end collision, whether somebody was ejected from the car. That's always signs of a very serious injury. Whether the car was totaled, for example, whether airbags were deployed, whether there was loss of consciousness. These are only a few things that you have to document as being simply the observer. And then you treat and you establish a doctor-patient relationship while you're also responsible to the industrial client who will pay your bill and may tell you when to stop, whether you like it or not. The third role is that of a medical expert, where you're not the treatment doctor, where you have no patient-doctor relationship, but instead you deal with what we will later see is by case law called a non-traditional patient. In that case, the employers, third-party administrators, or law firms are your clients. The patient is not, but you have some responsibility to your non-traditional patient with whom you do not have a doctor-patient relationship. So, approaching an injury, you ask yourself, what was the exit mechanism? And document. Were other people hurt, and how severely? were other people exposed or how severely? So as it relates to employment and exposures, you have to know what job site data, exposure data are available, what is known about similar workplaces, other bridges that have been sandblasted, what is known about fellow employees who all developed, let's say, COVID after exposure to a patient. The treating physician then makes a diagnosis, establishes causation, provides, using Melhorn's book, provides treatment using the college guidelines or other guidelines by the specialty societies, assesses the outcome, and calls a halt to the treatment when the patient reaches a plateau, and hopefully returns the patient to work. Now, an injury becomes reportable to OSHA when the patient is out of work 7 calendar days, and therefore the employer will put pressure on the treating doctor to send the patient back, even only to sit on a bench watching the other people work. And that pressure can sometimes be rather cumbersome. Here are the references. The Occupational Medical Department, Occupational College of Occupational Environmental Medicine has a practice guideline. New York has a practice guideline. There is a medical disability advisor that is available online because the college sold it to Dr. Presley Reed. Here is the reference. I personally feel, and don't laugh now, that the 1997 third edition of the ACOM guideline book is the best one ever written. And I had dinner together with other ACOM members while I was in Chicago and spoke to the person who put the book together. I've looked at the later editions and they only distract from the core, although some new matters will not be available. But this will ultimately find your way into your living room rather than on your shelf. Here are new editions of the ACOM guidelines. Here is a page of the MD guidelines from the web. Here is the front page of the third edition from 1997. Dr. Presley Reed is a still practicing psychiatrist. Nice guy. And then my friend T. Gadotti wrote that it is easy to design a protocol for the treatment of gallbladder disease. It's harder to design a protocol for the treatment of diabetes. It is much harder to design a protocol for the management of gallbladder disease in a brittle diabetic with hypertension. At some point, the clinical judgment of an experienced practitioner must prevail. So for a while, I worked as a consultant to a lady who ran the brokerage house, who was a former manager for the Maidenform Bra Company. And it was not easy to explain to her that sometimes clinical judgment had to prevail. The third role of the doctor is being a medical expert. And for that, you need to have special knowledge, history skills, and clinical skills. There are barriers, there are challenges. And here you see the doctor addressing the non-traditional patient. You can tell he's non-traditional from the print on the shorts. You establish a diagnosis. What happened? You take the history of the event and document. You describe the history exposure mechanism. Then you perform a clinical examination, and hopefully you've dealt with that situation before. Do not try to give a detailed neurological examination if you're only an occupational medicine specialist like I am. You make a diagnosis. You talk about causation. You give an opinion. You put that in a report, and ultimately you testify. That's what the expert does. The expert does not treat. There are various independent medical exams done either on behalf of the petitioner, namely the employee, or the respondent, namely the employer. They address causality MMI, is the examinee as good as he is going to get? The need to treat, namely, what does it take to reach MMI? The take over treatment, and he has supposed that the doctor who does it may be biased because he's asked to take over and make some money. The fitness for duty, where the Americans with Disability Act attaches, and permanent disability. Now, here's an interesting thing that I stumbled upon in the New York Times. There was a Mr. McWilliams on death row for a 1984 rape case and murder of a convenience store client in Tuscaloosa. Before his sentencing, his lawyer asked for psychological evaluation, and a court-appointed psychologist prepared a report that was distributed to both sides. Monday's argument in April of 2017 was almost entirely devoted to an attempt by the justices to divine what the predecessors had meant in the 1985 decision. I believe it's pronounced Akey versus Oklahoma. The money sentence in that decision, as Justice Elena Kagan put it, was this one, quote, "The state must, at a minimum, assure the defendant access to a competent psychiatrist who will conduct an appropriate examination and assist in evaluation, preparation, and presentation of the defense." The Supreme Court then ruled with an opinion by Justice Breyer that will be reviewed. Mr. Bright, a lawyer for McWilliams, said the Akey decision meant his client was entitled to his own expert, one who could help him prepare a defense. The late Justice Ruth Bader Ginsburg said, in that context of legal representation, there would be no doubt what assist meant. Assistance of counsel doesn't mean neutral. And Justice Alito said the opposite. During oral arguments, Justice Sotomayor said that the defense lawyer should be able to say to the expert, "I have to defend this man, give me my best argument." So if you're hired by a law firm, it is ethical to provide them with your best argument. In the majority's opinion, Justice Breyer determined that the Akey versus Oklahoma requires that a defendant receive the assistance of a mental health expert who is sufficiently available to the defense and independent from the prosecution to effectively conduct an appropriate examination and assist evaluation, preparation, and presentation of the defense, which means that the expert report on behalf of defense or respondent should be and could be a partial one. So here you're done, and there are leftover issues. There are some issues outside the scope of your claim, like the neurological disease that you find by coincidence, and that triggers a call to the client saying there are other things going on. Issues of individual public safety require a trigger call to the employer saying something's going on, you have to do something. You have to provide this person with an ergonomic keyboard so that she does not develop carpal tunnel syndrome. Issues with the examinee's general health trigger a letter to the examinee, and we will address that later, and this is very important. There's a case. Dr. Boyarski had seen a Mr. Reed for a pre-employment examination, which included a chest x-ray. The radiologist advised Dr. Boyarski of a widened mediastinum. And Dr. Boyarski passed on the information without commenting. And the delayed diagnosis of a Hodgkin lymphoma resulted in the patient's death 18 months later. This went up to the Supreme Court of New Jersey. The court's analysis of New Jersey law found that New Jersey has long recognized that a physician owes a duty of reasonable care to the non-traditional patient. That's where that word comes from, in the context of a third-party examination. And in fact, the State Board of Medical Examiners then published this NJAC 1335 policy regarding defense medical exams, ordering that the examiner should the examiner disclose abnormalities or conditions not known to the examinee, the licensee shall advise the examining to consult another healthcare professional for treatment. We'll address licensee below. This creates an imperative for the evaluating physician to directly communicate with the defense medical examiner, patient, any potential diagnosis of normal findings, with the recommendation to seek actual treating physician's opinion, with no need to go through the nurse, insurance adjuster, or vendor. This is a relationship between the medical examiner and the non-traditional patient. Ms. Cohn advised me of this regulation, and thank her. So this is what I have in my pocket. I have this letter where it says, when I interviewed and examined you on October 5th, 2024, I noted a medical problem that requires your urgent attention. I recommend that you either follow with your doctor or visit a hospital emergency room. Problems to be addressed are such and such. You have atrial fibrillation that you didn't know about. Go and see the ear. So you have to do it out of humanity and for your own protection. Here are the independent medical exams. This is a look of the office. And who are these people? Patients, lawyers, doctors, receptionists. According to the New Jersey statute, licensee means any person licensed and authorized to engage in a healthcare profession. The patient means any person who is a recipient of a professional service rendered by a licensee for the purpose of treatment. Examining doctors do not treat. Examinee means a person who is the subject of a professional examination where the purpose of that examination is unrelated to treatment, and where a report of the examination is to be supplied to a third party. That clearly defines the roles. IME is a forensic examination by a licensee, who is not part of the treatment team. The word independent comes from the fact that you're independent of the treatment team. Independent psychological and financial exams follow the same rules. Examinations do not establish a doctor-patient relationship. According to case law, the licensee is facing a non-traditional patient. Dr. Rischitelli said it's not the role of an expert to help the attorney win the case. It's the role of the expert witness to primarily assist the trier of fact to understand the complex issues at question. Expert witnesses must not become spin doctors for either side. So that would be overdoing it. In fact, here is what one of the patients wrote on my questionnaire. Said he was seen at Rothman and by spin doctors. In my practice, I see less and less malingering. And that's because I tell patients that I see myself as an assistant to the referee, namely the judge, and then add referees have two jobs. They call a fair game and they protect the players on both sides. And that creates an environment where people level with me, and I try to talk to him man to man, so to speak. And I make every effort to use what little Spanish I have, or use a professional translator. So regarding the Swogworth exam, you have a cover letter, a claim petition, and exit description. You can't really do your job with either one of these three, or with all of the three. Their treatment records, they're either authorized within the scope of the injury or unauthorized within the scope, because the employer did not authorize that, or unauthorized outside of the scope, namely it was a knee injury, but the patient is also being treated for the back, which caused radiating pain down the leg. The client cover letter that you receive should identify the cause, identify the jurisdiction, compensation either under a federal statute or a state statute, or under personal injury protection, or under medical or judicial malpractice. I see judicial malpractice cases. The cover letter provides a rough outline of the injury date. Now, dates are either a bracket of exposure or a date. Do not trust a date to be a date. A date may well be a bracket. This is one of the most important things I learned in the 20-some years. The cover letter is to be addressed, and people are very anxious that you do not address anything on the outside unless it directly affects recovery. It directs the expert source assisting the legal team. There are several kinds of IMEs. Causality, is the examinee as good as he or she is going to get? Need for treatment, what does it take to reach MMI? Take over treatment, fitness for duty, permanent disability. We discussed that before. In the need for treatment exam, the physician needs to understand the MMI concept. The physician needs to understand and apply evidence-based medicine and use the applicable laws and regulations. The physician should be experienced in treating that particular type of patient, and the physician should be independent of the treatment team. The administrator obviously has a bias to push you towards declaration of MLI because it limits expenses, the same way that the administrator has a bias for return to work because it limits the need to report to OSHA. In a complete IME report, you first disclose your possible bias, factual history, discussion of discrepancy, review of underlying and contributing factors such as age, nutrition, social background, social determinants of disease. You do a social thorough examination, analyze the records, analyze the treatment, whether it follows the guidelines or not, whether it's experimental or not. You give an opinion regarding causation, treatment, and recovery, and residual findings, and you provide references. It is bad to miss underlying conditions, prior injuries, prior settlements, other work, relevant hobbies, such as weightlifting, invasive treatment, intercurrent injuries of the same body injury that occurred after the incident, and medications. Has the patient taken their ibuprofen the day of the examination? You make errors when you don't disclose conflict of interest because that person may be a family member, or you may have treated that person before. You may give a wrong sequence of events. The right-left issues that happens quickly when you misspeak during dictation. There may be issues outside your area of expertise, and you may provide an ipsy-dixit opinion that is not grounded on references and therefore useless. For the accident claim, you have to elaborate whether the accident mechanism is a competent cause for the injury claimed and the diagnosis made. For the occupational claim, you have to say whether the occupational illness is characteristic of a peculiar trade, occupation, process, or place of employment. In the expert opinion on treatment, you can refer to specialty guidelines, for example, on pain management, the medical disability advisor by Reed, or the ACOM guidelines. You address this Melusina era at Studio. I had the pleasure of reading Tacitus in Latin when I was in high school. And he termed that term. The various translations, I would say the best one is without hate or zeal. Others say without either bitterness or partiality. You have to take a sober, factual look at things based on what you see and based on what you know. I was ahead of my time when I pulled out that slide, because I think this guy here with the red vest was the field surgeon of Attila the Hun, who met Pope Leo in 451, and Leo advised him he would give him some real coin, not Bitcoin, if he left Italy alone. Attila returned home, and then his troops were wiped out by smallpox, and Italy was saved. And this is the doctor guided by the employer or whatnot, and you don't want to be that. Our medical society provided an amicus brief on the Accutane litigation and said, medical societies have long recognized that members of their profession play a critical role in certain legal proceedings by providing scientifically valid expert witness testimony, cherry-picking advantageous evidence based on a party's litigation position rather than on generally accepted medical principles, arguably considers unethical conduct. This guy is apple picking. So, when it relates to net opinions, there is a rule 703 that addresses the foundation requirements for expert testimony. It requires an expert to ground their opinion in fact or data derived from all the following sources: expert's own personal observation, evidence admitted on trial previously already, or evidence of the type normally relied on by expert, which is known as the Frye standard. However, an expert is also required to give the why and wherefore in support of their opinion. In other words, an opinion considered a bare conclusion or speculative hypothesis, unsupported by factual evidence, called a net opinion, is inadmissible. So you better have in your pocket, in your bag, the relevant references. The Frye standard then, regarding expert testimony, during your testimony, and the court using the Frye standard must decide whether the methodologies used by the expert witness follow general accepted practices. The Daubert, that's how it's pronounced, standard, is reviewed in a hearing prior to your testimony. And under that standard, the trial judge becomes the gatekeeper and considers the following factors to determine whether the expert's methodology is valid. Now, hear this: whether the testimony or theory in question can be or has been tested, and whether it has been subjected to publication or peer review. That's where the thing in your pocket is handy. And whether it has known a potential error rate, and whether the existence and maintenance of standards controlling its operation, and whether it has attracted widespread acceptance, which is in fact the Frye standard previously examined. Now here comes something that is greatly affected by the patient's personal expectations, upbringing, etc. Hardiness describes a pattern of personal characteristics that distinguished managers and executives remain healthy under life stress as compared to those who develop health problems. Hardiness is defined as a personality structure comprising the three general dispositions of commitment, control, and challenge that functions as a resistance resource in encounters with stressful conditions. The commitment disposition is defined as a tendency to involve oneself in activities in life, as having a general interest and a curiosity about the surrounding world, activities, things, and other people. The control disposition is defined as a tendency to believe and act as one can influence the events taking place around oneself and participate in the recovery through one's own efforts. And that's why I said the new model in the recovery is not necessarily physician-patient relationship, but a bundle of partners in recovery. Finally, the challenge disposition is defined as the belief that change rather than stability is the normal mode in life and constitutes motivation opportunities for personal growth, namely coping, maybe with a wheelchair, rather than threats to security. Here is a book that gives the expected time of recovery. Employers rely highly on it. In summary, then, IME reports are biased documents by design created for the use in an adversarial system. They are prepared in support of either claimant and petitioner, defense, or respondent. The medical expert is held to the AMA Code of Ethics. The medical expert will base his or her opinion on peer-reviewed evidence and expert consensus. Net opinions are useless in the legal arena. And then the judge orders a settlement. The impairment guidelines. Impairment is a significant deviation from the normal body structure or function. Disability is a limitation due to that change. Limitation is a medical decision. Restriction is a social decision. Doctors look at function, then perhaps structure, what caused it, and then give it a name and find out what this case is worth. Lawyers approach it the other way around. What's this case worth? What does the MRI show? At 35, everybody has some disc abnormalities, so let's do an MRI. And then they want to see the more detailed evaluation of the function. I don't blame them, because this is how the system functions. Here are 6 editions of the AMA guides. I have them all. And here it shows that in Pennsylvania, we use the 6th guide. In the Federalis, we use the 5th edition. In New York, we have New York's own statutory rating system. And in New York, we have their own rating system. In New Jersey, we have the Fiddler on the Roof tradition. So, 5th guide for Federalis, 6th guide Pennsylvania, specific guidelines in New York. Society says offered guidelines. They look like this or like that. And in New Jersey, we have wizards above around 95, Jack Siegel, with whom I trained, below around 95, the late Dr. Sims, who created their own rating system. And then there's a Homo ludens, a man at play like myself, and the Homo faber, the man at work, who has either disability as partial total related in these areas, including the shoulder joint and hip joint, or disability of the arm from the shoulder on down, including the elbow, etc., as outlined here. By 98, I'd already done 30,000 back exams, and these are the ratings that I gave. I gave 135. I gave 35, 0 and 35%, I'm sorry. And I only gave 25% in one case. The others have made better recoveries. And incidentally, this is the frequency by half years, of which I found 0%. Interesting. Remained rather steady. So we have a few minutes I was hoping for. Let's quickly address functional capacity exams. Functional capacity is assessment of a person's physical ability to perform a job role. It's conducted by a physical therapist or exercise physiologist and takes 4 hours. The FCE involves a series of tests and observations measures physical capacity, namely lifting, carrying, pushing, pulling, balance, fine motor movements, cardiovascular tones, but it also measures consistency of effort, 2 totally different measures. FC is used to determine the functional capacity in objective manner using a preset protocol. In accordance with the response to these tests, the work capacity is then determined based upon the U.S. Department of Labor's Dictionary of Occupational Titles. In one of my reports, it said, "It is my opinion that there's a discrepancy between the patient's behavior and his demonstrable judgment medical findings. Therefore, I recommend that the validity of his complaints be ascertained by either a functional capacity assessment or by surveillance." By that, I mean video surveillance. If there is consistent performance, then this man should probably have a diagnostic arthroscopy. It is, in my opinion, important that he be brought back to work in a sedentary assignment for the time being. And then something happens. So, indications for MRI follow this 20 by 20 rule. If you cannot determine in 20 minutes in a 200 square foot room what is really going on, then the FCE is indicated. It will determine workability and impact of activity of daily living. Since the FCE measures both validity and capacity, it will provide insights and probably save money. And as to validity, where there is a will on behalf of the patient, there is a way. But if there's no will, no way. Prerequisites to do the exam are informed consent, personal statistics, definition of a clinical problem, daily activity profile, and a job description. The components are then the validity testing that you always look at first. the fitness testing, either cardiovascular or muscular, and then you arrive at certain limitations. The validity testing creates 5 different types. Either that person does as well as they could possibly do, or you see wimps with some maximal efforts, you see heroes, or you see patients that are all over the place. For example, in grip strength testing, the testing are all over the place. And sometimes you have indeterminate data. So wimps have fear avoidance, heroes perform above the norm, invalid people are trying to manipulate, and the FCE will help you find out who is who. Qualitative returns come first. If normal pain observed behavior, coefficients of variance above 10% on certain measures indicate inconsistency, and as far as the quantitative results, you stop. However, that person who performs consistent can then be assessed by the quantitative part of the exam. Therefore, where there is a will, there is a way. Here are the 4 common methods, and I won't bother with them. They come up in a different algorithm of displaying the criteria, and you have to know where to look for. That comes with experience, but I want you to know they're totally different ways of skinning a cat. When it comes to the musculoskeletal assessment, you look at posture, you look at positioning, you look at gait, including heel and toe gait, you look at movements, you look at inconsistencies. You measure hand strength, you measure static strength, you measure basic activity tests. For example, material handling, sitting, standing, bending, walking, material handling from floor to waist, from chair to waist, bench pressing, shelf, raising up to the shelf, etc. And then you see a data summary that has a heart rate profile, a behavioral profile with a pain report, a grip strength report, which is very easy to do. These instruments cost like $250. You can buy them yourself, and they give you a large insight on validity. It gives you a symptom or a disability profile. You get a body mechanism summary, and you get a percentile of strength from established criteria. The results then will display validity, cardiovascular limits, musculoskeletal limits, match against job description, match against dictionary of occupational titles, and recommendations. During the pulmonary cardiovascular assessment, you establish a metabolic rate where you expect the patient to consume 3.5 milliliters of oxygen per kilogram body weight in minute, or 1 kilocalorie per body weight an hour. And that establishes the MET, M-E-T. The active metabolic rate is expressed in multiples of that MET, and 2 METs would require twice the energy expected to use at rest. So there's a linear relationship between the oxygen consumption and the stages, for example, of the Bruce protocol. There is a relationship between the METs and the New Jersey Heart Association classification, where 1 to 2 METs means discomfort activity at any activity you can't get out of bed. Marked limitation, you can only be in a chair. Slight limitation of symptoms with ordinary activities, so you have trouble shopping, trouble even cooking and doing household chores. Over 7 METs, no symptoms with limitations, symptoms or limitations with ordinary activity. And this is about the range 7 to 8 where plumbers are. So here we have the measure that against the job description. 2 to 4 secretaries, machine assembly, 5 to 6 house painters, bricklayers, 7 to 8 plumbers, as I mentioned, shoveling dirt. So those are agricultural workers, for example, 9 above lumberjacks shoveling snow, lifting and carrying. That's why people sometimes experience heart attacks when they're shoveling snow. And the guide for functional ability was written by my friend Jill Galpine, former colleague in Boston, Elizabeth Genovese. It might be worthwhile to look at that book. In the process of the judicial system, it's like these market squares where the caller here is like the judge, and there are people that are dancing in circles. This may be the petitioner's team, that may be the respondent's team, and somehow they also have the matching step according to the caller. And together they produce that dance. With that, the fat lady sings, we are at the end. I'd be happy to entertain your questions.
If you have any questions, you can just raise your hand and we'll call on you. If not, this recording will be available on the MSNJ website, along with the slide deck for folks if they couldn't make it tonight or wanted to refresh their understanding of these concepts. So I don't see any Dr. Blumenthal. So thank you very much for a really engaging talk and staying within the time allotted. It's always great to do. So last call for any questions. Seeing none, thanks everybody for joining, and we'll get you back to the rest of your evening.
If I may just add one comment, my presentation provided quotes from the statute and provided checklists. So please feel free to use the slides. I thank you for the opportunity.
And Dr. Like has a hand up.
Thank you for your presentation, Dr. Blumenthal. Do you have any comments on what impact artificial intelligence is likely to have on the processes that you described?
This is an interesting question. Thank you for it. One of the mavens in independent medical examination, Chris Brigham, is presently providing training sessions in the use of artificial intelligence in providing independent medical examination. And he's doing very forcefully through all kinds of channels. At the same time, the people that I work for specifically give instructions not to use artificial intelligence in the history taking or in my reports. At this stage, I do not, so as to avoid that conflict of interest. And this is where we are.
Thank you.
Interesting. Well, thank you, everyone. And we'll adjourn at this point. So thanks, everybody. We'll see you soon.
Thanks, Larry.